So now we're going to move into the part 2, what to do when a loved one passes away. So one of the things that is very helpful is that in the front of your helper's handbook, there is a card that has on it, oh, I'm being reminded that I'm forgetting something again, but I'll still finish this. In the front of the helper's handbook, there's a card that has points on it of what you should do and what you should not do. So we're going to be talking about that again here.
I got here as quick as I could. When Dad died a few years ago, Mom handled everything. Now she's gone and it's up to us. Does anyone know if there was a particular funeral home that she might have wanted to use?
Well, I don't know, but I know she mentioned to me once that she wanted to be cremated.
Oh, I can't believe that. She wouldn't have wanted that. No, I won't agree to that.
I don't think she would have wanted an open casket or a viewing either. I'm not sure she wanted any service at all. Or at least I think she would have wanted something very small.
Well, we have to have a service. We're going to show people that we loved and respected our mother. She's not going to be buried in a pine box. We'll just have to figure out what would be nice for the family that are flying in and friends here in town.
Did Mom even have a will?
Well, I have a card for an attorney, but when I called that number, the number was disconnected.
Oh, great.
So I guess we're going to have to just search the house and see if we can find the will.
Oh my gosh, there's so much stuff in there.
Well, I think she may have had a will, but I think it's in a safety deposit box. I asked the bank about getting into the box, and they said I would have to get a court order
No.
to even look in the box.
Can't
Can you believe it?
Crazy. That's crazy.
To even see if there's a will.
Well, I hope she had a will because she promised some things to my daughter that I know my daughter would love to have.
Well, I hope they're not the same things she promised to my daughter.
Now, ladies, what are we going to do about the house? It's going to need to be cleaned out, and what are we going to do with the furniture?
And what about Daisy? Who is going to take care of her? Maybe we may even have to take her to the pound.
Oh, no, we can't do that.
Well, before anybody even thinks about taking Daisy to the pound, let's see if we can find anything as to what Mom wanted done with her. I don't think she would have wanted Daisy taken to the pound.
No,
Mom loved that
definitely
dog.
not.
That dog was a
Yeah.
faithful companion to her, gave Mom someone to love and take care of, and I know that the dog loved her back. Maybe the next door neighbor would take her.
Well, I'll pay for Daisy's food, but we'll have to find someone to take care of her after I leave because I can't take her to Michigan with me. I know that's just not going to happen.
Well, and I can't take her back to Wisconsin either. Maybe the next door neighbor would take care of her until we can find a home for her, if they don't want to take her.
And how are we even going to pay for the funeral?
I don't know. We may just all have to chip in to pay for the funeral until someone can get permission to use some of Mom's money. Lori, I know that your husband has been sick and you haven't had a lot of work lately, so the rest of us will just have to cover things until someone is able to use Mom's money.
And so where are the keys to the house?
I don't know.
And should we have the locks changed?
Can't I use Mom's car while I'm here? I hate to rent a car.
Really?
Don't look at me like that. You know Mom loves me. She would have let me use the car.
No, but you can well afford to rent a
Now,
car.
ladies, just...
Maybe we should contact the insurance agent for the house and the car. We need to find out what's legal. Does anyone know who that is?
I have no idea.
I sure wish we had talked to Mom before she passed away.
Me
about all
too.
this.
This is not going to happen to your family because you are watching this presentation. Our next segment is what to do after your loved one has died.
After a person passes away, then the process of winding down their affairs does begin. And that's referred to as trust settlement or trust administration. So the card that's in the front of your book will say, do call the law firm immediately. What the response that you're going to get from us is going to be, take care of the things that you need to take care of for yourself and your family. But we will schedule an appointment after the funeral and after maybe other people have come into town as well. So you do also want to review the final arrangements instructions. Again, you have a copy of that form in the Helper's Handbook, and that's another document that's in the Client Trust Handbook as well. Now, I will tell you that many of our clients, once they have filled out that form and thought about what they would want for their final arrangements, will then take it to one of the funeral homes here in town and work with my good friend, Fern McReynolds, who I've been referring clients to for 15 years. She handles the advanced directives, advanced planning for both of the funeral homes here in town. And so many of our clients have entered into some type of prepaid funeral plan. And I really encourage my clients to do that, because I know from experience of working with clients and working with families that when those kinds of arrangements have been made, it is a huge burden that is lifted off of the shoulders of the people who are left behind trying to make decisions at a time when they may not be in very good shape to be making those decisions. So we do encourage our clients to do that. You do also want to arrange for the immediate care of pets. To help people for both disability and for planning when they're gone, we do give our clients pet cards. It's a little yellow card that we encourage clients to fill out and have in their wallet to show who they want contacted in the event of an emergency to take care of their pets. Clients, if any of you have pets and don't have one of these cards, please ask either Jean or Lori for one, because we will be glad to provide those to you. And if you've had a change in your pet so that now you need to make a change on the card, we will always give you another card. All you have to do is ask us. You do indeed want to call the insurance agent for the auto in the home. The issue there is that when someone is gone, the insurance for the automobile may be gone also, and that is something that should be checked into. Also, if the house is going to be empty, then there may be a different insurance rate that is going to be charged. And I have had the situation arise, or I know of a situation, it didn't happen to one of my clients, but I am aware of what happened, which was that the house was empty, a pipe broke, it flooded the whole darn place, and the insurance company refused to cover the damage because they had not been notified that the house was empty, that it was not being occupied. And so you do need to make sure that the insurance for the home is brought up to date with regard to whatever the situation is going to be. And then, as I say, we will schedule a conference for you with us with regard to the next step to take. And for that conference, please write down your questions. Otherwise, I have people come in saying, I had a whole bunch of questions and I can't think of any of them now. I love written lists, because then we can walk right down the list and address your questions and get them answered. The card also says, don't do this, and don't do this. Don't race to the bank to close accounts or distribute money. Despite warning people not to do this, we had this happen in a settlement this last year, and we really had to scramble to figure out how we were going to have those assets be in a protected trust share, which I'm going to talk about a little bit more, which is the way that assets are generally passed out in the majority of our trusts. Don't roll over IRAs, 401ks, or other qualified retirement plans. Financial advisors tend to want to be very helpful, and so they will run over to the surviving spouse and immediately have them do a spousal rollover. That's not always a good idea. Usually that is what will happen, but that's not always the right thing to do. And to prevent that, we generally, to the extent that we can for those tax-deferred accounts, have the trust named as the beneficiary of them, and that slows the financial advisor down a little bit. Don't drive the decedent's automobile unless you're the spouse and it's a jointly held car. The issue here, and the reason that we did put it into our little vignette of Can I Drive Mom's Car, is that we have people that fly in from around the country and they see the car sitting in the driveway and they think, well, why should we rent a car? Why don't we just drive that one? Well, there's a couple of problems with that. One is that, as I said, when the person is gone, the automobile insurance may be gone. But even if the automobile insurance is not gone, if somebody is driving that car, they are exposing all the assets of the trust to the liability of that vehicle. That's a really bad idea. So even if there is insurance, I mean, if you have a big enough crash, there won't be enough money in the world to cover certain kinds of liability. What we want to do with those cars generally is get them out of the trust very quickly, Many times people will want to take a car as their share of, as part of their share of an estate, and they'll want to drive it back to wherever it is that they live. And so if the car is in the trust, which we do, then we can have a successor trustee transfer the vehicle out of the trust and either get it sold or get it to someone who wants to take it as part of their share of the estate, and then that limits the liability. It gets rid of the liability of that car in relationship to the assets of the trust and all the other beneficiaries of the trust as well. But again, if you're a surviving spouse and it's in your trust, you know, we're not saying that you shouldn't be able to drive the car. Don't remove household furniture and furnishings. Don't start divvying up the personal property, and don't pay any bills. Ask for a 2 to 4 week extension on the funeral expenses. But again, if your loved one has a prepaid plan, then that's not going to be an issue. And don't use the credit cards or debit cards unless, again, you're the spouse and you're joined on the account, or you're an authorized signer on that account. But otherwise, using those cards by family members after someone is gone is fraud, and you don't want to be doing that. Don't contact life insurance and annuity companies. We'll help you with that, and we can do it more quickly, and we can do it in a way that will maximize the benefits to the people that are going to be the beneficiaries of those accounts. And we'll talk to you about the options for things like annuity streams, whether to take it as a lump sum, what the tax consequences of that would be, why you might want to take a stretch out, and how long you might want to take a stretch out of any type of tax-deferred account or annuity type account. And don't use any powers of attorney. Those do end when the person ends, except for certain rights that do survive under the healthcare power of attorney to implement funeral arrangements and to make organ donations and such. But otherwise, the general durable powers of attorney end when the person does. And again, that would be fraud if they're utilized, and so people should not do that. Bring a written list of questions. We will send you a list of documents to bring. We will talk to you about what the next steps would be in the settlement process. And do understand that the ethical guidelines that I'm required to operate under by the State Bar of Arizona require that I meet only with the successor trustees and named beneficiaries of the trust. So spouses who are not beneficiaries, for example, cannot come into the settlement conference. And it's not because we don't care about you or anything, it's because that's what the ethical guidelines tell us that we have to do. So in the settlement conference, I would then be talking about what does this specific plan provide for this specific situation. And we'll talk about the settlement process, discuss possible tax planning strategies that may be available at that time. There are also some asset protection strategies that are available on the death of the first spouse or the second spouse. And the spouse may be asked to make some decisions with regard to those asset protection strategies. In a nutshell, without going into a long-winded explanation of this, it involves the question of, do you want to put this trust through probate? Which sounds like an absolute, just the weirdest question in the world, since part of the purpose of creating these trusts, a very small part of it I would add, is to avoid probate. There are times when, for asset protection reasons, it actually does make sense to put the trust through probate, because the decedent's trust settled for a surviving spouse by a court order can be protected from long-term care expenses of the surviving spouse if the surviving spouse has to go into a long-term care situation. And it's a quirk of Arizona law and DES regulations that we have the ability to do that here in Arizona. So if you're talking to somebody from another state and they're going, you know, what the heck, why would you do that? It's something that may not be available in another state, but is available here in Arizona. We'll figure out who's going to do what. Do you want us to call to have the locks changed at the house, or are you going to do that yourself? And we'll establish timetables for getting things done. Address questions, talk about our fees for assisting with the settlement process, and we would ask the successor trustees that have been appointed in the event of death to sign an engagement letter with us at that time. So there's kind of three main time periods. As we know, someone is alive and healthy, And then there is that disability period. And something that I forgot to talk about when I was talking about the disability determination process in the previous presentation is that, frankly, going through that entire 9 or 12-step process, whatever it is that we outline, has only happened in our practice twice since 2006. More often, what happens is that somebody reaches out to us. Maybe in one case it was a caregiver that said, you know, I've been going over to his house and I can see that there are bills that are not open. Sometimes they've been open and the check has been written, but it hasn't been mailed. He's just really struggling. Can you talk to him? And I said, absolutely. Why don't we make an appointment and have him come on in, and I'll see what he's feeling about this. And so I gently said to the client, you know, she's very concerned. Would you like some help? And his response was one of enormous relief that I had addressed him with this question. And so he made the decision in the counseling session to have her appointed as his co-trustee. She was his successor trustee already, but he decided to have her appointed as co-trustee so that she could help him with those things that he was struggling with. And then recently, the other client that I was talking about, where we just did some work for her, she called me up and said, I can't remember how to balance a checkbook anymore. I'm not getting my bills paid. I really need help. And so I reached out to her successor trustee, who is a licensed bonded fiduciary here in this community, because she has no family, and so, you know, I are it along with him. And when she came in to sign new documents to appoint him as her trustee, she's no longer the trustee of her own trust, but she does retain control over all of her own assets to the extent that she wants to exercise them. He's now her immediate power of attorney for financial matters and immediate power of attorney for health care as well. Her biggest worry was what would happen to her 3 dogs if she had to go into a care facility. And finally, what I said to her was, the people in this room will take your 3 dogs if that is what would need to happen to make sure that they have good homes. So when Lori had to talk in the vignette, somebody had to raise the issue of what do we do with the pets. She was the one that got stuck with that unpleasant task, knowing that the whole room, including us, would groan at even the idea of taking a dog to the pound. That's just not going to happen. So, I did want to say that the disability determination process in every case, other than those 2 where the one gentleman hit his head, so now we had an emergency bright line situation, in every other case, the control and assistance has just kind of slid over to the people who are already in place, that have already been chosen by the trust maker. And I think the reason that we do have that slide is because people are so confident in the decisions that they've made, the training that their helpers get in our training sessions, and they're confident that we are going to be there to help their helpers with whatever it is that's going to be needed on their behalf. Well, then we also get to the third point where, sadly, we lose clients, and then we're working with their loved ones. So I wanted to give you an illustration of how most of these trusts work. So this would be either a single person or a surviving spouse now had a trust, and once that person is gone, then an administrative trust is formed. And once the administrative trust period is completed, then the trust will split out to the ultimate beneficiaries. Now, we could have assets so that they were passed out outright, but the problem with that is that if that beneficiary then is driving along on an icy night, maybe going a little bit too fast, hits a patch of ice, and hits a school bus, this is one of those situations where what I say is, I don't care how much car insurance or umbrella insurance you have, there's not enough money in the world to adequately compensate for the death or the severe injury of a child. So what that means if assets are handed outright to a beneficiary, everything they own in that situation could be subjected to a catastrophic judgment creditor's claim, including what has been left to them by you. So instead of having that happen, we will do something a little bit different that I'm going to get to. Before we get through the administrative trust process involves building an inventory. Well, remember what I said. We try to keep up on our client's financial situation by having them help us. And so mostly it's a matter of printing out an asset detail report off of the computer, and that tells us what the assets are, where they're located, what the account numbers are. We do need to get valuations. So for things like financial accounts, stocks, for example, we have to take the high on that day of death and the low on that date of death, and then we average it. That's what's required by IRS rules to tell us the value of stock. Bank accounts are usually pretty easy. We can just get a date of death value from the bank, including any accrued but unpaid interest on accounts that, like CDs and such. Houses, though, or any kind of real estate, we do need to get appraisals for those because that sets the value for the purposes of determining capital gains tax. One of the loopholes, I guess you can call it, and it's a huge one for the middle class, is that assets are valued as of the date of death for those assets passing to beneficiaries. So there can be huge amounts of capital gains that have built up in some assets. I mean, I have assets that clients own. Someone has some farmland that had a very low value to it. It's located in one of the northern states where there are oil fracking going on. That farmland has tremendous value now, not only as farmland, but also because of the mineral rights. Well, when those assets pass out of that estate, it's going to be revalued as of the date of death, and all of that capital gain from the time that he acquired that property to the time of death will be wiped out. There will be no capital gains tax on it. So we do want to get those valuations to make sure that we maximize that benefit of what's called a step-up in basis for the benefit of the ultimate beneficiaries. We also want to identify, and in some cases, Paulette has done a wonderful job of negotiating down debts that have been incurred by someone prior to their death, and make sure that all final expenses and debts are paid. And we track the income within the office. We track what's going on with income so that we can provide information to tax advisors and CPAs to make sure that all appropriate tax returns are filed and taxes are paid. We don't personally prepare any income tax returns or tax returns for final returns for the decedent or for the trust or any federal estate tax or other types of tax returns. We refer those measures or those items that have to be taken care of to appropriate tax advisors. If the family has a tax advisor that they're comfortable working with, then we're comfortable working with them. If they don't have a tax advisor or the decedent didn't have a tax advisor, then we do have a short list of tax advisors that we are comfortable making referrals to. And a big part of the process that we go through in the administration phase is to educate beneficiaries with regard to the benefits that are going to be passed to them as a result of the trust planning. And then we implement the asset transfer process as well. This whole process will take anywhere from 3 to 12 months. I mean, obviously, if somebody passes away in the middle of the year, we can't do their final income tax returns until the following spring. There's actually 2 periods of time then for taxes, from the beginning of the year to the date of death, and then there's another time period from the date of death to the end of the year for the trust itself. So we'll have periodic meetings. Mostly those are done by telephone, and they're mostly done by Paulette because she is the funding and settlement coordinator. And then she, of course, is working under my supervision and brings to me any issues that she needs any help with. And that's a picture, by the way, of our new conference room at our new office out on Highway 92. The successor death trustees, again, are named in Article 15 for married clients' trusts and Article 12 for single clients. That's in the red book now. They assume complete financial control of the trust assets on the death of the trust maker, and they have to follow the directions in the trust as to what they're supposed to be doing with respect to those assets. And they're responsible for the management of assets. Now, one issue that we bump into every so often is that clients themselves may be very comfortable with investments that are a little bit riskier in an effort to get a better return on their investment. but the successor trustee has to, and this is true for disability as well, does need to follow what are called the prudent investor rules, which means that the assets may need to be transferred to investments that are a little less risky than what the trust maker was comfortable having. So now there's 3 types of distributions. The first type is what we call special stuff. And I have an example of special stuff that has been provided to me today. This is the petrified potato. Okay? So I well remember when I did this plan that there was about a 15-minute discussion by the Dipvigs, who have been so kind as to allow me to talk about this petrified potato and even brought it in for me to show it. There was about a 15-minute discussion of who should get this petrified potato. So it's not something that has any particular value. It reminds me of my grandfather's watch, which is what I wanted as a memento of my grandfather when my grandmother asked me. And my grandfather's watch, I've seen those little railroad watches on eBay for like maybe $5, so it doesn't have any great value. But every time I talk about that watch or I look at it in the little case that I have it in, I think of my grandfather. Well, the petrified potato was from great-grandfather George. And it's kind of a family joke. It's been passed down in the family. And so we've talked about it in these presentations, and they were so kind as to bring it in today so that I could show you that the petrified potato actually exists. So the things that go on the special stuff list tend to be, what I say is that men tend to leave guns, tools, and automobiles. Women tend to leave jewelry and furniture. It's the heirlooms, and I encourage people. We did a program a few years ago, and I'm probably going to repeat it this next spring because it has been a few years, and the program is called Who Gets Grandma's Yellow Pie Plate? And it's a great program that's put out by the University of Minnesota that talks about how to divide up family heirlooms and family possessions in such a way as to bring families together instead of blowing families apart. Because studies have shown that disputes are 5 times more likely to erupt over items of tangible personal property as erupt over financial matters. So we want to encourage a process that enables those items to be divided up in a way where everyone feels that it's been fair and that they are satisfied. And so we do encourage our clients to reach out to their family members and say, hey, is there anything that, you know, Mom or I have that you would want? And it can be the oddest thing. It could be the toaster, is the example that's used in the Who Gets Grandma's Yellow Pie Plate, because in some family at some point the son always remembered the toaster as being the focus of Sunday morning breakfast, and that was a particularly warm memory for him. So it can be some oddball thing that you never even thought about that a family member would want, and we encourage people to find out what those items may be. And then if there's more than one person that wants the same thing, like we saw in our little vignette, then isn't it so much better to settle those issues while you're here instead of having that blow up after you're gone? I've seen the ill effects that can happen in families. It can blow families apart for a long time, for the rest of people's lives in some cases. Now the specific distributions are in Article 7. That is where I ask the question during the design and counseling process, do you have any church or charitable organization that you might like to leave a sum of money to? Sometimes the dog or the cat is left with a sum of money to someone to take care of that animal for the rest of their lives. Sometimes it's just a neighbor or a friend or someone who has been particularly supportive in someone's life that they want to remember. Sometimes it's a charitable organization. But if there are any specific distributions, then they are found on the list that is at the end of Article 7. And then whatever is left, all the other stuff, is divided up among beneficiaries that are named by the trust makers in Article 9 of a single person's trust and Article 12 of a joint trust. So I've once again jumped ahead of the slide. Not everybody completes a special stuff list. If they have completed a special stuff list, it's going to be toward the back of the red book under the tab that is labeled. It's the second to the last tab that's labeled personal effects. So if they have a special stuff list, then that's where it is to be found. And it'll say, I want this item to go to this person and this item to go to that person. So not everybody has one of those lists, but we always ask. And then I've talked about the items in Article 7 also, and the percentage distributions. So now, again, I want to emphasize that almost all of the trust that I have prepared provides for the beneficiary's inheritance to be passed to them in trust, in a trust box, so to speak, for their benefit. Notice this does not mean that the beneficiary does not have control over that trust. Typically, the trust makers will say, you know, if they feel that the beneficiary is a responsible person and can manage their own affairs, then the beneficiary can be the trustee of their own trust. I've already talked about the school bus story. I don't think I had the school bus actually in this presentation until I had one client that said to me, I've never been to a presentation when you didn't have that school bus slide in there. So I put it in, because we've got to have the school bus slide. And we literally call that story of driving along on an icy night, maybe going a little too fast, hit the patch of ice and hit the school bus. We call it the school bus story. It's a shorthand way of saying that we're talking about protections. We're talking about asset protection for the benefit of beneficiaries. So the school bus trust can protect against the catastrophic illness protection. So what I say is, if, you know, God forbid that school bus should hit your beneficiary, then everything they own, if it's been passed to them outright, could be subjected to going through what's called a Medicaid spend down as a condition of the receipt of public benefits, unless the assets have been passed out in trust. Catastrophic judgment protection, also potential divorce protection, because it's very clear that when assets are handed out to a beneficiary in a trust, those assets are the sole and separate property of that person. They don't get sucked into a marital estate, and they don't end up then being divided with what I call the outlaw that used to be an in-law. And so you can pass on protections in the event of a divorce. And sometimes people will say to me, well, I don't need to worry about that. My son or my daughter has a very stable marriage. Well, what if that beloved son-in-law or daughter-in-law dies? And now the beneficiary marries someone who is maybe not so great. Having these protections in place is better than not having them in place. There's also bloodline protection. The issue is that if you leave assets outright to a beneficiary, if they're married, typically they will have an estate plan that says, if I'm gone, I leave everything to my spouse, and if we're both gone, we leave everything to our children. Well, if your person dies and leaves everything to a spouse, if that spouse remarries, what happens to your grandchildren? They can get left out in the cold. This is not an academic discussion in my family. In my family, my aunt predeceased my uncle. My uncle remarried. When he died, now his second wife and her son are farming the family farm in Wisconsin, and my 7 cousins of that first marriage are wondering what the heck happened to their inheritance. With trust-based estate planning, the trust maker can say, my person can use these assets during their lifetime, but when they're gone, I want those assets to go down the bloodline. And we can build in provisions for a beloved son-in-law or a beloved daughter-in-law to be able to have the use of some assets, get the income, for example, for a period of time, or maybe even their lifetime, or until they get remarried. These are all counseling issues that I go through with trust makers at the time that we're creating these estate plans. And there's also the ability to have what's called values promotion. A lot of our trusts are set up as what's called conservative access for the beneficiary, which means that the beneficiary can get all of the income from the trust paid to them or for their benefit, but the principal of the trust should not be accessed by the beneficiary unless they have a genuine financial need that cannot be reasonably met with other resources that are available to them. That's kind of a way of saying, you know what, I worked hard for this stuff during my lifetime. I would thank you to think about using the principal of these assets. I'd ask you to think about that carefully before you do so. But since many of the beneficiaries are also their own trustees, well then who's going to be making the decision whether they have a genuine financial need that cannot be reasonably met with other resources available to them? Well, they are. So by using conservative access, We can build in some values promotion. We also get some additional creditor protection by using conservative access, but we can still have practical control for beneficiaries if that's what the trust makers have elected. Now, these types of what I sometimes call legacy trusts or protective trusts, they only work if two requirements are met. One, the beneficiary is not the sole trustee. So that means even if the beneficiary is a trustee, we do require them to choose a co-trustee. But they choose the co-trustee is the point. They choose who they want as a co-trustee. They set the terms of the engagement. They also set the terms of the compensation. And a beneficiary has to be educated as to what actions could destroy the trust protections. So I've had beneficiaries say to me, well, can I take this other money, my savings account, and put it into this trust? No. You cannot, because then you're commingling your own assets with these assets that have been left for you by someone else. Because what we're doing here is we're taking advantage of a principle of the law that says when someone settles a trust for the benefit of someone else, those assets that are in the trust that's been settled for the benefit of someone else can be protected from the beneficiary's own creditors, the beneficiary's own catastrophic illness or accident, and the beneficiary's divorce. So we want to make sure that people understand that they cannot and should not commingle their own assets with one of these trusts. Trust settlement instructions are under tab 7 of the Helper's Handbook, a set of general trust settlement instructions, and then tab 8 has frequently asked questions, and it provides a summary of common questions and answers that we do find people have. And then there is the resources tab as well. And we're here to help beyond the legal issues. I guess that's part of the point of why I told, a little bit of why I told the story of the lady that came in, is that when she first called me, the first thing I did was reach out to the licensed bonded fiduciary. We'll find her whatever she needs to help her stay in her home for as long as it's possible for her to do that. And I know that the licensed bonded fiduciary, Mario Gonzalez, is a very caring person who he keeps a very close eye on the people that he works for. And she trusts him, and so do I. But I'm there as the backup as well. And then, as I say, we do have the glossary, which defines various terms and acronyms and stuff. So now this is some new material that I know some of you have been to this training workshop several times in some cases in the past. And this is a new piece that I've added in to the material. So the question is, how do you like horror movies? Well, okay, I see Dexter here going, yeah, I like those. But for most of my clients, it seems like the older they are, the less they like them. So I do need to clarify that we're not really talking about the modern day slasher movies. What I'm talking about are the older movies that have like Lon Chaney or Bela Lugosi, the classically trained actors where the movies themselves were put on more like a play, a stage production, rather than the productions of the movies that we see today. So keeping in mind that I'm talking about those older ones, you know, I usually find that there's a little bit more positive feeling toward those. You're all at least familiar with what I'm talking about, aren't you? So I'm seeing some nods of the heads here. Okay. So the question now is, how would you like to star in one of those? Now that's the thought I want you to think about. All right. So when there's a werewolf movie, there's always some background. You know, they'll introduce the characters, and there'll be kind of a set sort of cast of characters. You have people meet each other, so you get to know them, and you know it's coming though. Right? Somebody's going to get bitten by that werewolf. And there's even in the more recent movies, they'll even kind of laugh about the rules because there's different rules in the movies. And so they'll even do, you know, sort of self-referential laughing about, you know, what the rules are. And so you get to know the main characters, and there's always kind of, there's always a love interest because, you know they're going to get bitten by the werewolf, and why would you care if you don't have some investment in them? And so there's always a love interest. So then the attack occurs. The werewolf bites the person. Now, it gets to the point where people are so familiar with this story that I feel like, you know, some of my clients could probably tell the story for me. I wouldn't really need to tell it myself. There's always a survivor. Somebody has to survive, right? Because, you know, you got this story and there's somebody that has to survive in the story to keep the interest. And there's always a friend who knows everything. You know, sometimes the friend learned about it through some sort of goofy mechanism where a book falls off the shelf and it opens up to the picture of the werewolf and the story and description of the werewolf, or sometimes there's something like a woman at a seance, or sometimes there's just a know-it-all friend that just kind of knows everything. And there's always going to be advisors. There's always people that say, oh, there's no such thing as a werewolf, or you haven't been bitten by a werewolf because the doctors say this or that, and so, you know, that's just a bunch of hooey. So that you've got this cast of characters there. So now, oh, I jumped ahead of the slide. Okay. How do you kill a werewolf? Okay, and who fires the silver bullet? No, that's not the right answer. In the old stock storyline, it was always the loved one that had to fire the silver bullet. Now, Rick Randall, who is the director of the National Network of Estate Planning Attorneys, has said that his favorite session of this was where someone in the background called out when he asked the question of who fires the silver bullet. The person yelled out, "The Lone Ranger." Well, that's true. The Lone Ranger does fire the silver bullet, but that's a different movie. That's not the one we're talking about. But the point is, it can't just be any bullet. And more importantly, it can't just be any person who fires that silver bullet. So by now, you're probably all thinking, what the heck does this have to do with estate planning anyway? Well, what it's about is how do you kill, or more accurately, control werewolf behavior? Because we don't want you to kill your mother or your father, the surviving spouse, or a brother or a sister, an adult person that may be exhibiting what we call werewolf behavior. When people go through the grieving process, you see these books and it talks about the stages of grieving, of anger and depression and bargaining and such, and it makes it sound like it's all nice, neat, and tidy, and it's not nice, neat, and tidy. It's really stressful. And people all go through it, they all go through it in different ways and at different times. But the important point is, people that are going through that process very frequently are just not themselves. They are just not the people that we got to know over 6 or 8 or 10 years. We have the situations where, and we literally have had this situation happen in our practice within the last year, which is why I've added this material to this presentation, of the nice lady who I've had a relationship since 2006, who's yelling at me over the phone, who is impatient, has forgotten all of the reasons why we did the planning in the first place, and she's just not herself, and that's just, they're emotional, it's just not who they are. So they're like the werewolf. And how do you control werewolf behavior? Well, one way is advanced preparation, talking about what can happen to people that are dealing with this terribly, terribly traumatic situation of having just lost a spouse or having just lost a parent. And another way to deal with it is to set proper expectations. Now, naturally, helpers, what would you do if you don't have training about how this can happen? You're going to support your mother. You're going to support your father who's in pain and who's complaining about everything and everyone around them. This isn't fair, life is not fair, this is a terrible time, and they'll on and on and on. So what would you do? You would support your parent. Well, the problem is that supports and encourages this behavior that is actually not characteristic of them at all and can be very destructive with respect to the implementation of the estate plan. So we have that same cast of characters that we're still dealing with here, the survivor. So we have the surviving spouse, or we have surviving children, and it's, you know, if it's an adult child, that is exhibiting this kind of behavior, it's not quite as shocking to us because we haven't been in a long-term relationship typically with them as we have with the clients. I mean, the hardest ones truly are the really sweet spouse that is just not behaving like herself at all during this time. That's tough. It's really hard. It really is. You've got, you've still got the friend who knows. Who's the friend who knows? Well, everybody is the friend who knows. And we've kind of lumped those people together all in one, and I'm going to introduce you to a character. We call her Marge. And Marge holds court at Burger King, where she goes to get her senior coffee every morning. And Marge knows everything about everything. And so we get the well-meaning friends, the neighbors that say, well, why are you doing that? I don't understand. Or the financial advisor that says, why do you need a trust? You had a living trust. You've avoided probate. I don't understand. That's not what happened when my father died. That's not what happened when George died. Don't you have to file something within a certain period of time? And we get all this garbled stuff that comes back to us in the office. And so I ask them the question of who you've been talking to. And the trained people pretty much kind of shut up when I say that. I mean, I've had it happen. I'll say, you've been talking to Marge at Burger King, haven't you? And people that have heard this story then will kind of laugh, and I'll say, who told you that? And what did they say? And then then the person usually, if they've heard this story, they laugh about it a little bit, and at least they understand that I'm probably going to contradict whatever it was that somebody else told them, whether it was a well-meaning neighbor or the financial advisor. See, the financial advisors, they know a piece of the process, and the CPA knows a piece. Well, if you rely upon those other people for the portion of the process that is our part of the process as the estate planner, you're going to end up really frustrated and confused. And we don't want that, because that just adds to the stress level of what's going on. So the important point is support and honor the process itself, because the process produces the results that the estate plan was created for in the first place. That's why we have this process, is because the process produces these results. So it's only the loved ones that can help to survive the attack. And what's the attack? The attack is the death. And so helpers, you can say to mom who is complaining about everything and upset and impatient and emotional, there's a process, Mom. Just settle down. We'll go through the process. Or you can say to Dad, this is a process, and this is why you picked this gal. This is why you picked this law firm, is because you knew that they would have this process to implement what you want in your plan. So it's the adult child or the helper that is there to assist and support a person through this process. And it might be another adult family member. It could be surviving spouses. Those are the ones that are the toughest, because the instinct of the children is to rally around this grieving, hurt parent and support their behavior. And it is the exact opposite of what will produce the result that was the objective of creating this plan in the first place. So this is why I'm bringing this material to people, because we've actually experienced this in our practice here with a couple of times, and so it was a good time to bring it in. An important point to understand is, although I've been talking about documents, it's not about documents. It's not about pieces of paper. We go through some stages with these plans. We have the initial excitement of the creators and the advisors, but we also run into something that we call the parking lot rule. And that comes from a lady who said that after she walked out the door, she felt that everything that she had just been told was falling out her ear and hitting the parking lot. And so we go through these, repetition is the key to retention. So we go over these things to make sure that people are able to, if you don't know anything else, if you don't remember anything else, remember that we have a process. And if we've talked to you about something once, then it's going to be a lot more familiar when you hear it a second or third time when the time comes that you need to hear it. And we do also get the people who tears are coming down their face and they're laughing at the same time about one of the stories that we use to help support people through this difficult process when someone is gone. They'll talk about the school bus story, or they'll talk about another story that I've told, because it helps give people something to hang on to in going through the process. So our goals here today are for you to know the law firm and our contact information, to be able to put some faces with names, to know who I am. You know that Paulette is our funding and settlement coordinator. Jean and Lori are our client services coordinators, so when you call the firm and somebody answers the phone, you're able to put a face with that voice that's on the other end of the line. And remember that there is a process, and that the process is what produces the results that are the objective of creating these plans in the first place. And we want to give you some idea, some heads up of the issues that you're dealing with, and encourage your interest in the planning participation as well by making sure that things get done that will make your job easier in the end, if they do get done, are in fact completed. So we do recommend that you attend this presentation again within the next 2 to 5 years, and we do offer other educational programs throughout the year. Now, one of the educational programs that I'm going to be putting together for 2015 that I think is going to be, I think I'm going to be able to have it available as an audio, as an MP3 file on our website, is how to maximize your inheritance. So that's going to specifically address for beneficiaries what can be done so that you do maximize the benefit of the inheritance that you're receiving from loved ones as part of this planning process. And thank you all so much for coming. Oh, we've got one more vignette. It's a good thing I've got team members. They've got my back.
I can't believe Mom's gone. It just feels so strange to be sitting here in her dining room and she's not here.
She should be right there with us.
I know.
I'm so used to having her making coffee cake and coffee for us, especially when you two come in from out of town. And I was expecting to be able to smell that aroma
Yeah, it's just
and
not the
that
same, is it?
coziness, the comfort, and it's not here.
No, I know it. Well, let's take a look at this book. One of these, Lori, isn't one of these yours? And
Yes.
Jean, is this one Mom's?
Yes.
Yeah. Okay. Isn't there something I did?
Oh, yeah.
It's been a while since I looked at. Oh, that's right. There's
This
this
is
card.
from trustee training, isn't it?
Yeah. Well, you and I watched it on DVDs,
That's
but
right.
they were able to go since they
That's
live here
right.
in town. So
Yeah.
I know Jean is the healthcare agent, so she's had Mom's book. When I looked at this a little earlier, it said that the first thing to do was to call the law firm, and so actually I already did that, and I got an appointment for us that's next week for all of us after the funeral. And the contact information was all right in here, so that just made it really easy to be able to do that. They told me that Mom kept her red book with all of her estate planning documents in the den, and I already knew that because Mom had mentioned that to me
Okay.
too. So I've got it here, and we can take a look at that as well.
All right.
The next thing on this card list is to review the final arrangements.
Yeah.
Doesn't Mom have some instructions about what she wanted for her funeral service in there?
Yes, she does, and it's behind tab 6.
Oh, yes, I recognize Mom's
It's
writing.
called
Yep.
her instructions for final arrangements. And I went to the funeral home with her a few months ago too, after she filled this out, and she talked to me about it, and then she signed a contract with the funeral home for what she wanted, and she paid for it, and it's right here in the book. And because I'm her healthcare power of attorney, I'll make sure that all this is done as she wanted.
Well, I'm really glad that she did that, and I'm really glad that you did that with her, Jean.
Yes, I'm so
that is
glad
such
I'm so
that
glad
is such a
happened.
relief to know that that's been taken care of.
Well,
Yes.
she's done so much for me over the years. It was the least that I could do.
Well, I'm just glad that we don't have to try to figure it out.
Right.
We don't have to figure out what she wanted,
Yes.
how to get it
Mhm.
taken care of, or how to pay for it. I'm really glad that
Right.
that's been done.
And I've even talked to the neighbor that Mom made arrangements
Oh,
with to take care of Daisy.
And that's good.
They are all set to handle it.
They're
Thank
such nice
goodness.
people.
That's
I
great.
know Mom left some money for them too in the trust to help take care of Daisy for the rest of her life.
Yes,
I'm
yes.
glad Mom did that too.
That's true. I'm the
not the least
successor.
bit surprised.
No, I'm not either. And I'm the successor trustee of the trust, so I'll make sure that that's taken care of.
Oh, good.
And I'll also I'll be able to take care of the bills once I meet with the lawyer and get the paperwork I need. And I'll change the locks on the house. But can I drive the car?
I thought there was something on that card about that, wasn't there? There's something on there on that?
Oh, I see it.
Yeah.
Don't drive to
Don't
see the
drive.
car.
Don't drive the
Okay.
car. Okay. And it also says don't take anything out of the house,
Right.
and don't pay any bills. So
Oh, okay.
so
I'm gonna wait.
we can just wait until after we meet with the lawyer to find out about all
Right.
those
Okay.
things. Does anyone know where Mom's credit cards are?
I'm sure they're in her wallet still.
You think so? Okay,
Yes,
because
probably.
it says don't use the decedent's credit card, so we should probably find those and at least put them in a safe place until we find out what we're
right.
supposed
That
to do
makes
with them.
sense.
Yeah.
Okay.
Mhm.
Okay. I think we should all just write down any questions that we
That's a
have.
good
and
That's
then
a
we can
really
bring
good
that list
idea.
to the
Very
attorney
good
I
idea.
just,
when we meet.
things are just so foggy. I'm afraid I'd walk into the lawyer's office and
Right.
forget everything that I
Yeah.
wanted to ask. So
Me
I think it's
too.
a really good idea to
Yeah.
write down the questions. So I'm
Yeah.
glad.
I'm still so upset, so I'm really glad this list is here for us.
Yeah, that is really helpful.
These are
Uh,
all
makes
things
sense.
I was wondering about.
Yeah, it
Isn't
sure
it
makes
wonderful?
things a lot easier, doesn't
Yeah,
it?
isn't it wonderful that Mom made all these plans for us how to take care of things? It was so loving on her part, and I'm so glad that her attorney and her team are ready to help us with whatever we need.
Me too.
Yes.
Me too.